Good day, everyone. I'm Ethan, moderator for this webinar. Welcome, everyone, for today's webinar, HIPAA 2023 Latest Guidance and Compliance Focus. I would now like to introduce our presenter for today, Jim Sheldon Dean. Jim Sheldon Dean is the founder and director of compliance services at Lewis Creek Systems LLC, a Vermont-based consulting firm founded in 1982, providing information, privacy, and security regulatory compliance services to a wide variety of healthcare entities. I would now like to hand over the floor to the speaker. Over to you, Jim.
Thank you very much, and welcome everybody to today's session, looking at what we might expect this year in the world of HIPAA. And we keep hearing rumors of more updated rules and things like that, more discussions of what ought to go into updated rules. We'll see what actually happens. One thing I've learned over the years is when it comes to changes in the rules, the most important thing is that you'll, So we'll see what are some of the latest guidance items, what's the compliance focus that we're going to have here, and what might we have ahead of us here. So what might we expect as far as regulations are concerned? One thing that may be changing this year, as we're hoping for anyway, is they're talking about discontinuing the public health emergency for COVID-19, which will change the things in terms of HIPAA that are flexibilities and exemptions during the emergency for enforcement purposes. A lot of the flexibility is going away, so we'll need to think about, well, when the official emergency is over, what does that mean from a HIPAA standpoint? And also, we'll be spending some time looking at the issues of individual access of records under HIPAA. This is a big area for our friends at Health and Human Services. This is an area where people have had a hard time just forever in getting copies of their records, or getting a copy of the records sent to their new medical provider. Sometimes it would really help if your current provider could see the records for what was done in the past and be able to review that stuff easily. And sometimes it's just impossibly hard to get access to those records. And this is something that HIPAA allows for certain rights for individuals that a lot of organizations, a lot of healthcare providers haven't really been following appropriately, and that leads to a lot of enforcement activities. So we'll see that there's plenty of entities that have gotten into trouble for not handling individual access appropriately. So we'll be looking at what's involved with that and be able to remind you as to why that's an important thing to do, because it's an important topic under a number of headings. And we'll look over what are the proposed rule changes and also potential rule changes. There've been some stuff proposed, but when it comes to new technologies and various HIPAA controls, there's a real disconnect. There's a lot of stuff that people are using these days, various apps and things that handle health information. So anyway, we'll have some time for some questions at the end. As we say in engineering, my vast background of experience. Anyway, there's things that are, we're looking at today have to do with the HIPAA privacy and security and breach notification rules, okay? So part one, let's look at the various regulatory expectations, where the regulation's going, what kind of modifications and guidance we have out there. Yeah, as far as basically as a result of the HITECH Act, which was passed in 2009. And as I mentioned, information blocking, this is a hot topic at HHS. So we do have these new rules that are in place to help facilitate the exchange of health information. Now, when it comes to accounting of disclosures, just touch on this, briefly here and a little bit more later on. But what we're talking about here is the individual has a right to an account. This is one of these things that is so underused. HIPAA and 42 CFR Part 2 have always been in conflict. I mean, Part 2 has been around for a lot longer than HIPAA, for 2 decades longer than HIPAA. Under the updated rules, I'm sorry, the updated rules already. But then also we have the November 2022 proposed rules. I got a couple slides on that, though. What they proposed just last fall, have a process to deal with complaints about dealing with adverse actions against people who file complaints that quite often these days involve systemic non-compliance. And as I mentioned, some state attorneys general have been busy. Some of the recent HHS security rule enforcement, just going back a few years, so long as you can show that you've been meeting good practices, okay? That means even some great stuff from the Department of Energy that helps you understand where you are and how you can improve things and helps you. We can touch on telemedicine here briefly. Now, HHS does have an enforcement advisory about telemedicine, that there are plenty of HIPAA allowances for communication when it comes to family and friends of patients, okay? So this is, it's a group of records maintained by or for a covered entity. It has to be for a reasonable cost-based fee. Now, there's also been a federal court ruling that has to do with the release of information to third parties. And we can see that the guidance on access it will be largely codified by the proposed privacy rule changes. Now, as far as access enforcement actions, they go way back. I mean, this is just going back into the beginning of 2021. We have other ones going on into 2022 and 2023. I mean, it hasn't ended. Now, when it comes to HIPAA and patient communications, where does this come from? We talked about, communicating with the patients. Number of items they listed, HHS did for their business associate liability. Now, when it comes to other things, we'll talk briefly about accounting of disclosures changes. So what they recommended was a staged implementation with pilot testing based on real technology using certified EHRs only, not just anything that's electronic, and getting back to normal after the pandemic. I mean, that's just, that's acknowledging the receipt of the notice of privacy practices and retain that. Now, so when it comes to TCPA, again, it does limit calls and messages to cell phones. We have new technologies in healthcare all the time, okay? The idea is, if it's at the request of a provider, the same technology might be under HIPAA. So your to-do list is, first of all, don't be in denial. So thank you very much for listening today.
Thank you, Jim. That does conclude the session for today. Thank you everyone for participating.